In a medical malpractice lawsuit, if the judge refuses to allow your medical expert to testify, can you still prove your case? Can you still go forward and have your case presented to the jury? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now you're in the middle of trial. You brought a lawsuit against your doctor claiming that he violated the basic standards of medical care. And now there's a clear dispute. You believe the doctor was careless. The doctor turns around and says, no, I wasn't. You believe that your injuries are caused by his carelessness. The doctor turns around and says, hey, your injuries are not as a result of anything that I did or didn't do. And then you claim that your injuries are significant and permanent. The doctor, on the other hand, turns around and says, hey, your injuries really are not as bad as you claim them to be. So there's a clear dispute. And now you need the jury to decide whether you are more likely right than wrong that what you are claiming is true. So now, during the course of your trial, the judge, for a number of different reasons, refuses to allow your medical expert to testify. And now he tells your attorney, listen, call your next witness. Now the attorney has no other witnesses. Can you still move forward and have the jury decide your particular case? In New York, the answer is no, you can't. You want to know why? In New York, in order to get your case in front of the jury, you have to be able to show that you are more likely right than wrong, and you have to have a medical expert, at least one, to confirm, number one, that there was wrongdoing, number two, that the wrongdoing caused injury, and number three, that the injury is significant and or permanent. So why is that? It's because that the medicine involved is something that requires medical expertise to explain to the jury. It's not something that involves common sense. So now we have to listen to medical experts explain why something was done wrong. We have to have medical experts explain why that wrongdoing was a cause of your injury. And now we have to have medical experts explain why your injuries are significant or permanent. If you don't have a medical expert, now you cannot go forward. By law, you cannot proceed forward. The judge will throw your case out before the defense ever puts on any of their witnesses. So to go back to the original question I asked at the beginning, if the judge refuses to allow your medical expert to testify, can you continue forward? The answer is no, you can't. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I recognize and I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.